On this morning's Ag Issues program, as always, a pleasure to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, and he joins us on the program this morning. Roger, how are you this morning?
I'm just fine, Greg. Good to be back in studio again with you.
Absolutely, and we've had some major cases recently to talk about, and obviously there's a big one Friday that we're going to discuss here in a second, but the first one we want to discuss came out of Iowa, and this has to do with the regulation of ag runoff, and I think people have heard many issues about that, whether it's a legislative issue or not. Yeah,
this matter has been going on for a good decade in the state of Iowa. It's been known as the Waterworks decision in the prior versions of this. But basically what has happened is you've had some groups and some individuals, some activists up in Iowa that have been pushing for further regulation of farming practices along certain rivers, and one particularly that flows through Des Moines. And so you've got a metropolitan area, and their drinking water supply, they claim, is at risk here. And the Des Moines Water Works is in Des Moines, and they're responsible for cleaning things up and making the water in the river drinkable, potable water for citizens in the urban area of Des Moines. So you go back about 10 years, and this litigation started, and what they are upset about is they claim that the legislature hasn't done enough to regulate these practices. And so you got a buildup of nutrients, phosphorus and nitrogen, as a result of runoff from farm fields. Well, the Supreme Court has consistently said in Iowa that this is a legislative matter. We're not going to jump into this. If you don't like it, get different politicians in place. But this is not for the courts to deal with. And so we had the most recent iteration of this last week in Iowa. Again, another Supreme Court opinion. And this time, the groups came at this with the angle of, well, the public trust doctrine should apply. And, Greg, I wrote a post on the public trust doctrine, actually two of them last fall, because this is a trend that we're seeing being pushed in the courts. And agriculture is kind of in the crosshairs of this. The public trust doctrine is an old doctrine, and it's been around for hundreds of years. And it's found its way into the common law in the United States and in statutory law at the state level, too. And what it basically comes from is the notion that certain natural resources are to be used by the public. The intertidal, or the sea in general, the oceans and the intertidal waters are not to be privately owned. They're for the public to use. And so you can fish over them, you can boat on them, those types of things. And I'm speaking very generally. Well, the effort has been to take that doctrine and expand it to have application to private property, particularly where you own farmland next to a stream or next to a water course. And they say, well, you know, the endangered species that might use that stream, you can't withdraw so much water for irrigation purposes that it would deplete the water in the stream because it would affect an endangered species, and those are for the public. So because the state hasn't stepped in to regulate your practices, we're going to use this doctrine to expand the regulation. So it's not just that. They've also tried to use it to minimize oil and gas drilling, other types of practices that are important for agriculture. Well, that's what was going on in this case. And so they tried that theory. And again, the Iowa Supreme Court said, no, we have a very narrow view of that in Iowa and the statutory law as well as prior court decisions, and we're not going to expand it. That is the domain of the legislature. And the plaintiffs were arguing, well, the aesthetics of of the river would improve, our members would feel better. They were making one of these types of really arguments that, you know, our members would feel better if the river is cleaned up. Their water bills would go down because the waterworks down in Des Moines wouldn't have to expend as much funds to clean it up. And they could recreate and emotionally they would be better. And the court said, we're not going to deal with that. That's an amorphous concept. This is all policy issue that's left up to elected officials. And so they refuse to expand the doctrine.
It's like a painting with a 6-inch paintbrush and an 18-inch paintbrush in so many aspects.
Yeah, and the court said that's for politicians to deal with, and we're not going to address it. Now, it was close. I mean, there were dissents in that opinion, and so you switch a vote here or there, and the opinion comes out differently. And so agriculture's got to be aware of this movement. There is a segment in the law and in legal theory that's pushing this, and it's people that own property, large tracts of land that use natural resources for their living, as agriculture does. You're going to have to keep an eye on this. We've had cases over the past year, as I wrote about last fall, coming from California, some of the western states, but here's one from Iowa. And so far the courts have said pretty much across the board, whether it's Washington, Oregon, California, now Iowa, that now they're resisting the attempt to expand the doctrine. But that doesn't mean that'll always be the case.
And you'd mentioned two things, property and, in this case, water in Iowa. I would think that would be, in this case, two of the main ones that would be targeted under the public trust doctrine?
Yeah, it is. You're going to have to watch farming practices, irrigation practices, which would be monumentally important for a state such as Nebraska in corn production. I remember when I first started out practicing, the lead partner in the firm said he always loved it when it burned up in Iowa because they could just irrigate the corn in Nebraska, and prices would go up because the market people see that Iowa's in trouble, so the prices go up. He said we just turn that water on and keep pumping the irrigation in Nebraska. So you're going to have to watch it on these things. It could affect irrigation practices. It could affect all types of farming practices. But so far, again, just to reemphasize, the court in Iowa, consistent with what other courts have said over the past year, have said this is a matter for state legislatures to deal with. Keep it out of the courts.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. Well, Roger, Friday, the U.S. Supreme Court handed down the decision concerning, and this has to do with, of course, the small refinery exemptions, or a specific case of a small refinery exemption that ruled in favor of, I guess in this case, the refinery in this case too.
Yeah, not surprised by this. Normally, Greg, the U.S. Supreme Court won't take a case unless there's a split amongst the circuit courts of appeal. There was no split here. We just had a 10th Circuit opinion. And basically, the only time other than when you have a split that they need to clear up that they would take it is if you have a question, for example, involving a presidential election, or there's a state that's suing a state and there's an urgent matter that they have to deal with. Otherwise, they're not going to take it. So when I saw that they had agreed to hear the 10th Circuit opinion without a conflict, I had a pretty strong feeling they're going to reverse this. They view the 10th Circuit opinion as way off base, and that's indeed what happened. You have to look at the statute, the way that the RFP, the Renewable Fuels Program, was enacted back in 2005 and what the statute says. And that was where the mandate was included that says that you've got to increase the amount of so-called renewable fuels that are blended into what is being refined into your transportation fuels. And, of course, the big one for ag in that is ethanol. And the RFP also directed the EPA to extend an exemption that was contained in the RFP for 2 years if the mandate would impose, and this is the key language, a disproportionate economic hardship on a small refiner. Okay, so that's what the issue was in the case. We've got an exemption for small refiners that was to go through 2011, but they could apply for an extension if they could show a disproportionate economic hardship. So that extension was tied to economic hardship, which is going to change from year to year. And you've got several small refiners that had initially received an exemption, and they saw it lapse. It did lapse because the mandate was not imposing a disproportionate economic hardship on them at that time. So they let it lapse. Well, the economy changes, the market changes, and so now they've got a disproportionate economic hardship. They're applying for an extension now. They want a 2-year extension. And some opponents of that in the renewable fuels side of thing, the Renewable Fuels Association said, no, you let it lapse. You can't extend something that's lapsed. Okay, now on the surface, that kind of makes sense. When you look at the statute, as the majority opinion, this was a 6-3 opinion, said, you look at the broader context of what that is couched in. They said Congress often uses language like this, and they cited many recent statutes, including the Consolidated Appropriations Act of 21 or of 20, right? 21. It was enacted in late December of 20. And they said you can extend certain benefits that have already lapsed because they're tied to certain conditions. And so there's not a hard deadline on this. And there's no consecutive or successive language in the statute. And so the Congress didn't tie it to successive, consecutive, meaning it's tied to economic conditions. If the economic conditions change, and this market is very volatile, as the majority opinion noted, that fit with the at any time language that was also in the statute. So when they put all that together, they said, yeah, you can seek an exemption at any time, even though the initial one has lapsed at the end of 2011.
So how much of this then goes back, I guess, in one aspect, I read one thing that some of those who were against the Renewable Fuels Organization said it didn't necessarily look at the 10th Circuit's decision about causing financial harm. It was more about the extension versus. So that still obviously has not changed as far as the proof of causing financial harm.
I think that's right. One of the things the majority said here, and I think this is a real good point. This is something I've been saying for quite some time. Mandates, any type of economic mandate, whether it's this or anywhere else, it messes with the functioning of the market. And the court was concerned about that in the opinion. And in fact, they reasoned, part of the reason was that their rationale supported the notion for small refineries to receive an exemption for economic hardship based on fluctuating economic conditions rather than being forced to exit the market, which would, they said, make the U.S. more dependent on foreign oil if they had to exit because they couldn't get an exemption. That's your key right there. That the court said that's counter to the whole purpose of the RFP. We want to become less dependent on foreign oil, but yet if we don't allow this extension to occur, even after it's lapsed, because we want it to be, we think Congress wanted it to fluctuate with economic conditions, that facilitates the intent of Congress that these small refiners stay in business and we remain less dependent on foreign oil. That was a pretty important point that the majority opinion made.
And the extreme volatility of what we've seen in this case, RINs market, right, which is the credits in this, has played a huge factor because of where these small refineries end up being a financial standing.
And that was referred to by the majority opinion, and that bolstered their notion that you were able to seek an exemption at any time, and it didn't matter that it had already lapsed because they wanted it. They thought Congress wanted this tied to economic conditions so that these refiners could stay in business.
All right, let us move on to another big decision that took place. We're going to go out to the state of California, and this is as you put it, takings decision, or taking private property for public use without the owner's consent.
Yeah, this is a Fifth Amendment case. Again, U.S. Supreme Court last week, so we've had some really big opinions just in the last few days. And that for the U.S. Supreme Court, that happens near the end of June every year. They seem to save the big ones toward the end of June before they get out of town so that they can't get, I guess, egged. So we're going to issue these opinions, and then we're out for October, and then by the time we come back, people will forgot about what we did. But this is a big one. Some people will remember the name Cesar Chavez, one of the co-founders of the Farm Workers Union. That's not the official title, but he was a union organizer for farm workers back in the 70s, and California was kind of his focal point. And the legislature out in California passed a law in the mid-1970s, and then the state promulgated regulations that gave unions the ability to get access to farms for 3 hours a day up to 120 days a year. They can come on your premises and they can organize your workers and they can protest and those types of things. Now, that would seem pretty radical to us back here in the Midwest, but California, that's what they deal with. And so you've got in California, ag is the number one industry. It's the biggest ag state in the country, and I think we forget that because we kind of Los Angeles and San Francisco and San Diego, but no, it's a huge ag state. This is a big deal. And what had happened was some of these workers came in unannounced, 5 o'clock, or the union came in unannounced, 5 a.m. in the morning, had bullhorns and so forth, and they're upsetting workers at a strawberry farm in Northern California. They did it with a grape operation in Fresno also, and a number of these farms just said, look, there's got to be some type of restriction here. You're taking our property. We think this is a Fifth Amendment taking. So they sued. The Supreme Court hears the case, and it goes through the Ninth Circuit, comes to the Supreme Court, and the Supreme Court looks at this. And when you get into a takings analysis, there are various types of takings. Is it a physical taking or is it a regulatory taking? And we worry a lot in ag about regulatory takings because those are more often what's going on. It's not as often that the government comes and physically takes your property. They'll regulate the use of it. So at what point does that constitute a taking? And the court, the bottom line here, they said, actually, this is a per se physical taking because the state, by granting access rights to the union, took an easement, which is one of the rights of property ownership that an individual has, and gave it to somebody else. And there was no benefit coming back. Now cities can sometimes when you develop property, you dedicate certain parts of the property over to the city for roads and lights and those types of things. You're getting a benefit back from that. That's a little different. Or they'll exact a fee, but you're getting some type of benefit. Here the court said there's no benefit coming back. This is a taking. So we could do a lot deeper analysis on it than that, but I think that's what people need to recognize, that the court, I think, pushed the boundaries a little bit further into property owners' favor as to what constitutes a taking.
All right, Roger, we're out of time, but yeah, big week, or big last week, I guess, in this case, as far as the Supreme Court. But like you said, they're getting out of town later this week. So, get it done and get out of town and say,
that's right.
We'll see you in October, so to speak. So,
and maybe you forgot about these things by the time we come back.
Exactly. All right. That's Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.